essa oficina que se chama The Plea Bargain Machine, com o professor Jorge Bisharat, o professor Roberto Cante de Lima e o professor Ricardo Gueiros. Só para dar uma breve nota sobre a biografia dos três professores aqui, o professor Jorge Bisharat é formado em Direito e doutorado em Antropologia, ambos por Harvard. O título do livro dele se chama Palestine Lawyers and Israeli Rule, Law and Disorder in the West Bank. Para quem tiver curiosidade, tiver interesse, tem uma cópia desse livro no acervo, aqui no quarto andar. Bem, o professor Cante também é formado em Direito, para quem não sabe, na Universidade Federal do Rio Grande do Sul, e também tem um doutorado dele por Harvard. Daí essa relação com o professor Jorge, eles são amigos desde o doutorado. E o título do livro do professor Cante se chama Polícia na Cidade do Rio de Janeiro. Eu acho que está à venda ali. Está esgotado, né? Mas tem uma cópia também no acervo.
Está à venda.
Bem, o professor Ricardo Gueiros também é formado por Direito pela UNB, e mestre e doutor também em Direito na Gama Filho, com um período sanduíche na Hastings College of Law, onde o professor Jorge Bisharat também é professor lá. Eu gostaria só de aproveitar essa oportunidade para agradecer publicamente tanto ao professor Jorge como ao professor Cante, que eu fiz o meu sanduíche em 2011, pelo doutorado aqui de Antropologia, e eu tive a oportunidade também de aproveitar dessa relação dos dois, e o professor Jorge me aceitou lá em Hastings, e foi sempre muito gentil e muito paciente comigo quando estive lá. Então, eu queria agradecer a ele. Bem, finalmente, então, acho que a gente pode começar. O professor Jorge vai falar mais ou menos por 1 hora, depois ele falou que vai querer fazer um rápido intervalo de 5, 10 minutos, e depois a gente volta.
Eu quero completar essa apresentação. Ele explicou que ele vai falar mais ou menos isso aí, 1 hora, 1 hora e pouco, sobre os procedimentos do que eles chamam, né, de due process of law, quer dizer, o trial by jury. Aí vai ter um break, e ele, então, depois vai enfocar especificamente a questão da plea bargaining. E ele vai fazer isso através de um vídeo, que é um vídeo que ele produziu, vamos dizer, teatralizando vamos dizer, uma barganha junto com uma promotora, que efetivamente é uma promotora também. Quer dizer, ele o professor George, além das coisas que o Fred falou, ele era, quando eu fiz a minha pesquisa em 1990, nos Estados Unidos, o professor George era parte do Public Defender's Office de São Francisco. Quer dizer, ele era um advogado um defensor público, né, na cidade de São Francisco. São Francisco é uma cidade das poucas cidades que tem uma defensoria pública, né? Era até um cara português, que era o descendente de português, que era o Public Defender, né? E o professor Jorge fazia parte dessa equipe de defensores públicos, e ele, portanto, é um advogado praticante. Não é isso? Só que depois ele foi para Hastings University, que é Hastings College of Law, é uma universidade ligada à Universidade da Califórnia, em São Francisco, né? É uma faculdade de Direito da Universidade da Califórnia, em São Francisco. Só que ela é anterior que nem a Faculdade de Direito aqui, né? Ela é anterior à universidade, né? É a mais antiga Faculdade de Direito da Califórnia, né? E é muito tradicional e muito importante. E o professor George é professor de processo penal, é professor titular de processo penal nessa universidade. E aí, por causa dos encargos, ele até me explicou que ele um dia ele estava lá numa audiência e tinha uma aula, não é isso? E ele tem um hábito que ele está deixando de fora aqui, que é de começar tudo na hora certa, não é isso? Porque ele está socializando os alunos, né, a estarem na hora certa, na hora do juiz, porque o juiz não espera nada, porque aquilo ali são 2, 3 minutos que o cara fala, se falou, não falou, dança. Então, ele começa tudo absolutamente em ponto. Nós fizemos um curso com ele, que o Fred não fez, mas eu e o Ricardo fizemos, daí a ideia de fazer essa oficina, um curso que era uma clínica, né, de processo penal, e essa clínica de processo penal, então, ele começava pontualmente, quando ele ficava olhando o relógio, na hora que o relógio batia no 9 horas, né, começava 9 horas da manhã, 9h40, né, sei lá, batia lá, ele dava início à aula e tal, e terminava, né, também exatamente, né, na hora que eu tinha dito depois, né. Então, ele está aqui, ele está relevando esses hábitos e tal, porque, afinal de contas, nós não somos advogados norte-americanos, ele não precisa disso, nos socializar. Mas ele sofre um pouquinho com isso, não há dúvida. Ele ontem já estava dizendo, bom, eu vou chegar lá às 9 horas, porque essa troça vai começar às 9h30 mesmo, não sei o que, Eu digo, vai se acostumando com isso aí, que a coisa é assim que toca. Mas, então, essa ideia surgiu lá, né, quando nós assistimos esse curso, e o Ricardo fez uma tese, né, de doutorado sobre a plea bargain, que muito interessante, que também está aí, mas ele também fez um contraste com a transação penal e com os juizados especiais criminais, que é a parte que ele vai falar aqui depois que o George falar sobre o trial by jury e a plea bargain. E a grande questão, né, é que o próprio Ricardo descobriu isso lá, né, quer dizer que a plea bargain, né, ela está intrinsecamente associada ao due process of law, né? Embora ela não seja o due process of law, mas ela só existe porque existe o due process of law. Isso é uma coisa fundamental e é por isso que eu acho que essa oficina aqui vai tornar vários assuntos explícitos e tal, e eu não quero atrapalhar mais o George, que ele vai começar, mas eu achei que isso aí devia ser tornado público, né, para o público entender melhor as razões dessa... E o Fred fez uma pesquisa lá sobre os tribunais voltados para julgar os crimes ligados às drogas, né? Então, todo mundo aqui andou lá em São Francisco e daí essa comunhão, vamos dizer, de interesses, né, jurídicos e antropológicos. Vai lá, George.
Good morning, everybody. First, I want to thank Roberto and all of you, not simply for the opportunity to speak to you this morning, but really for my now 2-year relationship with InEAC. The first time I came here a couple of years ago, I was welcomed, and it was immediately apparent to me what a vibrant and vital and dynamic institute has been established here, and it has been my great pleasure over the last couple of years to host the 3 gentlemen here in California, of course, including El Jefe, my old dear friend Roberto, who is, by the way, a co-founder with me of the Bacardi School of Anthropology. I'm not sure if you're aware of this fact, but if you're not, you must ask him about it because it's one of his most important professional accomplishments. And then coming back this time, seeing all of the progress that's been accomplished by, by the young researchers here, getting to meet some of your other international colleagues, it's really been a wonderful experience. And what I really want, especially the young people involved in this institute, to understand is that this is a very special atmosphere that you've created here. The mutual respect, the collaboration and the support that you all give each other and that you receive from other colleagues is actually rare in academia. And the lives of many scholars are, in fact, quite solitary. And what I see here is a kind of a collective spirit and a collective effort that can really elevate you all together to much greater heights than you would be able to accomplish as individuals. And so I want you I mean, I've been to many universities in the United States and other places abroad, and I want you to appreciate and cherish what you have here, and also to be very proud of yourselves, because you are, of course, obviously part of this project, and it wouldn't be here without all of you. So it's really been a great pleasure, and so I appreciate the opportunity. I also want to apologize for my inability to speak to you in Portuguese. I'm always self-conscious when I go abroad and am forced to speak not in a native language, but in English. I also want to appreciate and recognize my interpreter, Ana Barreiros, and to, you know, it's a little bit, I feel a little bit like a child, you know, with somebody looking after me, but at least I'm a pampered child, you know, well taken care of. So thank you, Anna, for your help this morning. Okay, now let's talk about the plea bargain machine. If you asked a lawyer or a judge in the United States what typifies or what is most distinctive about the U.S. legal system, the answer is almost certain to be one of two things, or possibly both. The first reference would be to trial by jury. Simply an occasion in which 12 members of the community, usually 12 in any case, are brought into the court, and evidence is presented to them, and they are the determiners of fact. They are the ones who decide whether or not the defendant is guilty or not guilty. The other thing that they would probably say is that we have, in the United States, an adversarial system. An adversarial system is one in which the parties, the prosecutor and the defendant, are adversaries, and they engage in a form of combat or conflict in the court in which they are the ones who are responsible for bringing evidence before the court. The role of the court in this system is relatively passive. The judge has no responsibility to investigate or independently bring facts to the case. It is solely the responsibility of the two parties to bring that evidence. And the judge plays the role of a kind of a neutral referee or umpire to make sure that the rules are not violated in the production of this evidence. So it is a form of combat, but it is important to recognize it is a regulated form of combat. It's not a free-for-all. And there are ethical duties that both sides owe. Among them, this is not an exhaustive list, but a partial list. Among them, the obligation not to mislead the court, the obligation not to knowingly present false testimony or perjury before the court, and the like. So the two sides go at it and fight, but within rules and within constraints. Now, the truth of the matter is that this event, the jury trial, that is supposed to be so typical, almost never happens. And the overwhelming percentage of cases, depending on where you're looking, roughly between 94 and 97% of all criminal cases in the United States are resolved not by adversarial combat, but rather by cooperative negotiation. In other words, by plea bargaining. So plea bargaining, briefly, I will go into this in much greater detail later. Plea bargaining simply is a negotiation between the two parties to the case, the prosecutor and the defendant, about the disposition of the case, about how the case will be resolved. So what I want to try to do today is to explain this apparent paradox, whereby a system that describes itself as a jury trial system, in fact, becomes the plea bargaining machine. This is based primarily on my own experience as a deputy public defender. Roberto described to you my experience in practicing as a criminal defense attorney in the city of San Francisco. I tried myself a number of jury trials, and I plea bargained probably thousands of cases, and I was witness to many other thousands of cases that were negotiated in my presence by other attorneys. Accordingly, this is not a historical account. I'm not trying to explain to you how the plea bargaining system arose in time. Although I think that much of what I said, much that I will say, would be consistent with some of the accounts of the rise of plea bargaining that I have read. However, the reasons that a certain practice develop are not necessarily the same as those which maintain it and by which it is rationalized in the present. So I want to be clear, I'm not really talking about how this whole business got started. I'm talking about how it functions today and how people who are engaged in it think about it. This is also not a deliberately comparative presentation. So I'm not an expert in Brazilian criminal practices or criminal procedural practices, but I have done some research, and there are some aspects of what I will say today that are deliberately chosen to highlight differences between the two systems. Okay, sorry. Sounded loud to myself. Okay, so some of what I will be talking about is I have selected certain things to highlight differences between the American system and the Brazilian system. But mainly what I see my role in the seminar as doing is providing you with a building block with which you will be able to make your own comparisons. Now, I was able to understand that you've already been told that I will speak for roughly an hour. I'm adopting Brazilian practices when it comes to timing today. Okay, so roughly an hour about jury trial practices, and then in the second half of the presentation, I will shift to discussing plea bargaining itself. I do this because jury trial and plea bargaining are linked, and plea bargaining in particular cannot truly be understood except in relation to jury trial. Now, in the second part of the presentation, I will also share with you a reenactment of a plea bargaining session conducted by me and one of my colleagues at Hastings College of the Law. So you will get a flavor from that of what actual plea bargaining is like. And then at the very end, I will close with some observations about why our system, our legal system, continues to represent itself, or to perhaps misrepresent itself, as a jury trial system when it is in fact the plea bargaining machine. Now, two other quick things. If you have questions during my presentation that require a brief response, I invite you to interrupt me. Don't be shy. I would rather you not be sitting there confused, right? Longer comments, observations, questions, we can keep till the end when we have time for discussion. But if there is a point of clarification that you need, don't hesitate to interrupt me. The second thing is, I hope you don't mind if I use a little bit of profanity. And I will do this, I do this with my students in California because the world of criminal practice in the United States is extremely profane. Judges, lawyers use language that would cause proper people to be very embarrassed. And I like to prepare my students for this world that they're going to be walking into. And so I may, if you don't mind, I may go ahead with that a little bit here too. Very little. Okay. So, good. Glad we have that clear. Yeah.
Because they are my students.
Yeah. Okay. Now, one other sort of, as we get into the kind of the meat of my presentation, I want one other thing to be understood. So I'm speaking a little bit schematically. We have a federal system. Our political and our legal system in the United States is a federal system in which all 50 states are distinct sovereigns. The states under our federal constitution reserve any powers that are not explicitly delegated to our national government. The police power, which comprehends the power to define crimes and to prosecute them, is one such power reserved by the states. We do also have a federal criminal system, but there are relatively few federal crimes. And the vast majority of criminal prosecutions on an annual basis in the United States are conducted at the state level. The federal level is actually minute. Now, I will not pretend that there are no variations in procedures and practices from state to state. There are differences. However, these interstatal variations are not great, at least as compared, for example, to the differences between the US system and the Brazilian system. So, for example, all 50 states and the federal system follow the jury trial practice, with a whole set of associated practices and concepts, which I will soon share with you. However, 39 of our 50 states permit juries of fewer than 12 people, down to as few as 6 in misdemeanor offenses. Misdemeanor offenses are relatively minor offenses that carry punishments usually of 2 years or less, although it varies from state to state. So 48 states require jury unanimity for a conviction. In other words, all of the jurors have to agree on the verdict. 2 states do not. So there are many other procedural differences of this kind of scale. That is, and I personally see that as a relatively minor difference, at least, again, as we compare the United States to foreign systems. So that is why I think it is not an abuse to speak, as I said, schematically, somewhat generally. The reasons, I will just explain to you a few other, the reasons for this general similarity. So to begin with, our federal constitution was modeled after the constitutions of the 13 original colonies. There were constitutions that existed before the federal constitution. Almost all of our state systems also look to the British common law system for inspiration. Following our Civil War, there was an amendment to the US Constitution passed. It was the 14th Amendment. And that held that state governments could not deprive citizens of life, liberty, or the pursuit of happiness without due process of law. And there was a gradual process of enforcement of rights guaranteed under the under the Bill of Rights of the United States, the first 10 amendments of the U.S. Constitution. It was gradually held that all of the states had the same obligations to criminal defendants as did the federal government. And the way it happened was the courts would ask, well, okay, what is due process of law under the 14th Amendment? What does this mean that the states have to abide by? Does it include the privilege against self-incrimination, which is preserved in the 5th Amendment of the U.S. Constitution? Gradually, as the court faced these questions, it almost always answered yes. The states do have to abide by the same terms as the federal government. What this has done is it has established a floor of protections for criminal defendants below which the states cannot descend. They cannot dip below. They're free to be more generous to defendants if they wish, but they have to provide a minimum of protections established in the federal Constitution. So, of course, this promoted a level of national uniformity in criminal procedures as well. So that's a sort of a more elaborate explanation of why it is possible to speak in relatively general terms and be accurate. Okay. I'm going to talk to you at some length about jury trial practices, what we actually do when we do a jury trial. I'm going to cover these things. What is the theory behind jury trials? Why do we have them to begin with? Next, how do juries get formed? Where do they come from? Third, what sorts of rules of evidence are employed at jury trial? And then finally, how are juries supposed to operate? That is, how are they supposed to arrive at verdicts? And for each of these, I will go into some detail in trying to explain the procedural mechanisms that have arisen to implement these practices and concepts. Now, I'm going into, this is like a tour of the jury trial system, and there is a destination. The destination that I want to bring you to, that is the conclusion, the overarching conclusion that I want to drive home with you, is that jury trials, at least one jury trial conducted according to modern or contemporary procedural requirements, is an extremely cumbersome and costly affair. It is an organizational feat to pull one off, and it is at high cost in both institutional and social resources, okay? So that is the end point. That's the main conclusion that I want you to draw from what I'm telling you. However, there are hopefully points of interest along the way. I wouldn't go into such detail if I didn't think there was something worthwhile to be learned about how we think about these practices. So, okay. So, and of course, all of these things, as I said, are key to understanding plea bargaining. You can't understand plea bargaining unless you understand what has generated it. Now, while I focus on trial, which is definitely in our system the main event in a criminal prosecution, please be aware that some cases involve substantial pre-trial litigation. It's not just the trial. There are other things that go on. Most cases have at least some pre-trial litigation. All felony cases are more serious cases, generally punished by anywhere from 2 years or more in prison to death, right? Those are felony cases. All felony cases in the state of California have what's called a preliminary hearing. A preliminary hearing is an event in court when the prosecutor is obligated to bring in witnesses and establish probable cause that the defendant has committed the crime. It's an early kind of preview almost of the trial, and the purpose of it, the formal legal purpose of it, is to screen out weak cases and to make sure that only cases that have a substantial evidentiary basis go forward, okay? So all felony cases have a preliminary hearing, or at least can have. Another common example of a kind of pretrial litigation would be what's called a motion to strike a prior. Many offenses in our legal system involve allegations of prior convictions. And these prior convictions, when a person has previously been found guilty of a crime, right, that prior conviction can be alleged, written on the formal charging document, and if proven at trial by the prosecutor, can lead to far more severe sentencing consequences for the criminal defendant than if he were just facing the offense without the prior, okay? So priors are very common, prior allegations of prior convictions leading to elevated sentencing. And so litigation frequently focuses on whether these are in fact constitutionally valid priors. There are requirements for how convictions can be brought about, and the lawyer will scrutinize the record of the prior conviction and try to argue to the court that this is not valid. This is an improper conviction, therefore cannot be used to elevate sentencing in this new case, okay? So that would be another example of a common form of pretrial litigation. Now, there's lots of other kinds of pretrial litigation. I am not going to say much further about it. If you're curious about it, please ask me when we reach discussion. Okay, what is the rationale behind jury trial? Why do we have them at all? Two primary reasons. First, jury trials are thought of as a way to interpose the community between the individual and the state, and thus to offset the tremendous imbalance of power between the two. The state's power is vast. They have investigators, they have police, they have professional prosecutors, they have all kinds of things, and they have the reputation and aura of state authority, and when that force is brought against poor little individual defendant, that's a lot of force, and so here comes the jury to kind of stand between the individual and the prosecuting authority and to check its power and to deter or guarantee against the persecution of individuals by executive authority. That's one of the main reasons that we have jury trial, and it is specifically conceptualized as an emanation of our U.S. national identity as individualists who are concerned with freedom from central authority. The second reason that we have jury trial is, the argument goes, they're better. They help us arrive at more accurate verdicts in criminal cases. 12 minds are better than none, better than one, or three, or you know, different systems have different numbers of fact finders, but the belief is that if you have more people, that's better than having fewer people. Also, the jury is again, as representatives of the community. They bring diverse perspectives and a broad fund of everyday wisdom to the task of weighing evidence. And this is in recognition of the fact that that many judgments in criminal law involve assessments of human character. It's not all simple facts. So that may involve weighing the honesty or veracity of a witness. Okay, that's a judgment about somebody's character. Likewise, about the likely intent of a criminal defendant. These are not straightforward matters. So, so the idea is that a jury with its diverse experience can better assess these things than a single judge. However, and this is important, the truth-finding mission of jury trials is consciously balanced by other considerations. So a jury verdict is thought of as truth produced in a particular way with respect to particular rules. So it is call it a juristic truth or a legal truth as opposed to absolute truth. This is manifested, for example, in our unwillingness in our legal system to permit evidence that is derived from involuntary statements of the defendant. If the defendant has been coerced by trickery or by physical force, in other words, torture, we don't allow that statement into evidence, even if it may be true, and even if it can be established that the statement is true, for example, by corroborating evidence, right? So we don't let that in, and we consciously do not permit probative, relevant evidence because of the way it was obtained, okay? So we're striking a balance between absolute, I mean, we're not always getting absolute truth. We're getting a truth that is produced according to a particular formula and, as I said, with respect to particular values and rules. Now, these rationales, whether these rationales withstand scrutiny or not is not an issue I want to take up today. They are both debatable, right? Whether juries really actually bring more accurate verdicts or not, that can be argued. That's not my concern today. I'm trying to describe to you how it's thought about and how it's rationalized. Two other characteristics that juries in our system are supposed to have. First of all, a jury is supposed to be a jury of one's peers. Because to be tried by people who are totally unlike you and maybe unsympathetic to your condition seems unfair. Next is that a jury should be impartial. Impartiality means neutrality, being neutral, at least as of the beginning of the case, not having any predisposition to either convict or acquit. So, fine. Let's say you're convinced and you're ready to give jury trial a chance. What do you do next? Where does the jury come from? So, there are two kinds of juries, grand and petty juries, with different functions. I think grand juries, I'll just tell you about very quickly because they're not the principal concern here today. Grand juries basically are a group of usually 23 citizens who are selected by the court, and they're supposed to be people of upstanding moral character and the like, and they serve for a period of time, a year, 2 years, and basically they provide the prosecutor with an alternative way of screening cases to the preliminary hearing that I described to you earlier. A prosecutor, instead of taking a case to preliminary hearing, may present the case to the grand jurors, present evidence. It's a secret, closed proceeding in which the defendant is not present, And they decide whether to go forward, whether to issue a charging document and actually go ahead and charge the defendant or not. Okay? So that's a grand jury, but that's relatively uncommon in our, I mean, it's there, but it's not used very much. Petty juries, despite the name, petty sounds like they're not important. In fact, they are they have the important function, which is to hear evidence in a public trial to decide whether the defendant is guilty or not guilty. So where do petty juries come from? That's the main question. Let me remind you that this is supposed to be a jury of one's peers and also an impartial jury. So you could imagine that finding a jury of one's peers could be a real procedural quagmire. Does the requirement mean that if the defendant is a plumber, you need to drag in 12 plumbers to hear evidence against him? Must rich defendants have only rich jurors? Do black defendants require 12 black jurors? Is that the meaning of a trial by a jury of one's peers? Well, in practice, and not surprisingly, the requirement of a jury of one's peers amounts to little more than the right to have jurors from the same judicial district in which the crime is being tried. So what could have turned into a kind of a mess and a sticky situation, the courts have avoided by saying all you have to do is just bring in 12 people who more or less live nearby. Now, still, you have to round these people up from somewhere. I mean, how do you get them into the courtroom? How do we bring them and how do they end up sitting in those 12 seats? Well, we in each county have, or judicial district, we have a jury commissioner who is a local public official whose job is to generate lists of prospective jurors. So generally this is done through searches of public records. So voters' registration lists, the Department of Motor Vehicles, all of these kinds of public agencies that keep records of people's residence are plumbed, are explored by the jury commissioner, and jurors are summoned by letter to appear in court to serve. Now, obviously, this does not snare everybody, right? And there is a bias in this process in favor of middle to upper class people who vote, who have driver's licenses, who don't, who have a home and a mail address and aren't homeless or transient or poor so that they don't have a car, don't get a driver's license, etc. So there's a certain socioeconomic class bias already built in. Okay, what about impartiality? How do we know whether jurors are impartial or neutral or not? You can't know that in advance, right? So the only way to find out is to ask them. And because some jurors will doubtless reveal some form of partiality, yeah, I know the defendant, or I know the victim in the case, then you will necessarily need a larger pool of people from which to select your 12. And it is also necessary to have a larger pool because while jury duty is supposed to be a civic duty, courts recognize that this duty in fact can impose hardships on people. For single parents, for self-employed people or casually employed people, for sick or disabled people, or people who are unable to understand English. And then many citizens, while they report, they'll come to the courthouse, they view jury duty as onerous, as unpleasant, time-consuming, a waste of time, and therefore they do their best when summoned to escape actually serving. So it may surprise you to learn, or perhaps not given what I've said, that in order to generate a jury of 12 people, the typical jury pool that is ordered by a court to try a simple misdemeanor case would be maybe 60 people. Okay? So, by the way, it is never prudent to have only 12 jurors. What happens if one is sick, or gets sick in the course of trial, or is otherwise indisposed and can't attend? You either have to wait for that person to recover in order to resume trial, or you have to start over with a new jury, because you can't proceed with a juror who has only heard part of the case. They all have to hear all of the evidence. So, depending on the expected length of the case, and therefore the odds that some juror will fall ill or otherwise be indisposed, I mean, if you think about it, if a jury goes on for 2 or 3 days, that's one thing. But if it goes on for 2 months, which does happen, then the odds of somebody getting sick or something like that are much greater, right? So we always pick 12 jurors plus at least two alternates, and in most felony cases, 6 alternates, and in more serious and expected longer cases, we might have 12 alternates. So we're not just picking those who actually officially serve as jurors, but we're also picking alternates. And the alternate jurors sit through the trial and hear the evidence just like the 12 actual jurors, and then, if necessary, they can replace a sick juror without the case being interrupted. So what happens? You get a group like this, right? You actually look, like about the size of a jury pool, maybe not quite big enough for a misdemeanor case. So you all come into the room as prospective jurors. There's a court clerk sitting there with a hopper, which is a round basket with a crank on it, and usually she cranks it like this, lifts a little lid, pulls a name, and reads out the name. You go up and you sit in the jury box, right? And this happens 12 times. We get 12 people up there. So these unlucky people, as they see themselves generally, are sitting in the jury box, and they get questioned for bias, okay? Initially by the court. By the way, in our legal culture, when we refer to the court, we're talking about the judge, right? It's a way of aggrandizing them, I suppose. So the court and impersonalizing. So the court questions them initially, and this is to make sure that the jurors meet basic requirements, that they are actually residents of the judicial district, and that they understand English well enough. Many prospective jurors will be excused by the judge for reasons of hardship. I've given you already a couple of examples. I care for my elderly mother, and I can't be away from the house all day long, I can't serve. And the judge will say, fine, you're excused. Attorneys will also, after the judge questions, typically the attorneys will get an opportunity to question jurors for bias. And attorneys have the legal authority in our system to challenge, or to exclude, in other words, particular jurors. There are 2 kinds of challenges. The first kind is a challenge for cause. So there's an explicit, identifiable reason that this juror is inappropriate for this case. Person says, yeah, my car was broken into one time. I don't think I can be fair and impartial in a case that involves auto burglary. Or my sister was raped. This is a rape case. And I have such strong feelings about these kinds of cases that I don't think I can serve in this case. So in that situation, if the judge hasn't already, usually this is the game, the judge will say, well, despite that, can you serve and be impartial? Can you put that out of your mind and only decide the case based on the evidence here? And of course the jurors will say, yes, of course I can, Judge. And so, you know it's not true, right? But that's how it goes. The reason it goes this way, by the way, is because there's another form of challenge, which is called a peremptory challenge. And a peremptory challenge is a challenge that the lawyer can make without having to justify it. Okay? It can be, they just, like, that guy looked at me, that prospective juror looked at me fishily and, you know, with distaste, and it was evident to me, and I can't really pin it down, but I feel it, right? So in California, in a misdemeanor case and in most felony cases, you have 10, each lawyer has 10 peremptory challenges, right? And then in more serious cases, you can have more. So for example, in cases involving life sentences or the capital punishment cases or death cases, you have 25 each, right, of these peremptory challenges. So the reason the court says, no, you're going to be fine, right? You can be impartial, can't you, despite the fact that they've openly admitted that they can't be impartial, is because the judge wants you to have to burn your peremptory challenge to make you use up all your challenges so you can move along the case, right? So that's the game with respect to challenges. Now, the only limitation on peremptory challenges is that they are not supposed to be used in a discriminatory fashion. So, you know, if you have an African-American defendant, the prosecutor is excusing all of the black jurors, right, all of the prospective jurors, then you can bring a challenge before the court. You as the defense attorney can bring a challenge before the court that the peremptories are being used in a racially discriminatory fashion. Now, the game with that is the court is then supposed to, if there's a prima facie or if there's a little bit of evidence that in fact that's what's going on, the court then is supposed to ask, why did you exclude juror number 6, who's African American? Well, he has a mustache, and he has long hair, and to me that's an indication that he's undisciplined and probably not sympathetic to the police. That's why, not because of his race, no, because of his, you know, the shirt that he was wearing or whatever. And judges routinely accept these kinds of explanations for the exercise of peremptory challenges. So this supposed protection against discriminatory use of peremptory challenges amounts to not very much. Now, each time a juror is excused, and like I said, this happens a lot, right? Either for hardship, for cause, or via a peremptory challenge, right? Then another juror comes up, the hopper gets spun again, another name out of the hat, juror X, boop, and the questioning starts all over again with that person, right? First the court, then each attorney, et cetera, et cetera. Now, depending on the nature of the case, how serious, complex, lengthy, or sensitive, this process of jury selection, from herding all of the jurors down to the courtroom from the jury assembly room, which is elsewhere in the Hall of Justice, to actually swearing them in at the start of the case, takes at least a half a day for a petty offense. It can take, in a serious case, weeks or months. And if you have multiple co-defendants, for example, let's say 6 people are being charged in one case, which is possible. You'll have six defense attorneys. They all get an opportunity to question the jurors, right? So so the process of jury selection can take a really long time. I myself tried a misdemeanor case in which the jury selection took 3 days and the trial itself took 2 days. So, you know, it gives you a sense of how cumbersome this whole process is. Legally speaking, the purpose of this process, by the way, we call this the questioning of the jurors, voir dire. This is supposed to come from Old French, and it is supposed to mean to speak the truth. If you come from the American South, it's pronounced voir dire. So voir dire, the legal justification for it is to reveal bias. That's all it's for. In fact, in reality, the way it's used by attorneys is to begin to try their case and to begin to persuade the jurors of their position. So, I would ask as a defense attorney, have you ever heard Juror X about a case of misidentification of a defendant by a witness? Are you aware that cross-racial identification in particular is unreliable? So I'm starting to tell them what my theory of the defense is as I'm questioning them. They're not even on the jury yet, but I'm starting to sell my case already. Okay, so let's say we finally have our jury and we're ready to proceed to trial. So what are the principles and methods of proof that we employ at trial? Here are some basics. We have a presumption of innocence. That is, as we begin the case, at least, the defendant is presumed to be not guilty, and the burden of the proof is on the prosecutor. Generally, in our legal system, the burden of producing evidence rests with the person who is making the affirmative claim, right? And in a criminal case, case wouldn't happen if the prosecutor didn't say, hey, this person is guilty, right? So it is the prosecutor that is the moving party in a criminal case, and therefore the burden of proof rests with the prosecution. The standard of proof, that is the measure of how convincing the evidence must be, is proof beyond a reasonable doubt. I will come back to all of these. This is supposed to be just a list at this point. Next, the defendant has a privilege against self-incrimination. Fourth, character evidence is generally inadmissible. Next, the exclusionary rule is used for evidence that is illegally obtained by the police. Following that, we have a right of confrontation and the right to cross-examine witnesses from the opposing side, called by the opposing side. And the defendant has the right to counsel. And for the last 50 years or so, an indigent, a poor person who can't afford to hire counsel, is entitled to court-appointed and paid counsel in any case that leads to actual incarceration or prison. So, I'm gonna run through these. How am I doing for time? How much? Do you know how much time I've used up? 50? Okay, I'm gonna speed up a little bit. So, let me try to briefly go through each of these. So the presumption of innocence, the prosecutor has to bring forth evidence that meets this burden of proof beyond a reasonable doubt, and if he or she fails in that, then the jury is supposed to find the defendant not guilty. The prosecutor goes first at each phase of the case. I'm going to skip over. I would, with more time, talk about the phases of a trial, but I don't really have time, I think. So another implication of this presumption of innocence is that the defendant doesn't have to put on is under no obligation to produce evidence, and can argue at the close of the prosecutor's case, and without saying anything, him or herself, through counsel, of course, you failed to meet your burden of proof, right? I don't have to show anything. You did not show what you needed to show. The prosecutor is also not permitted to comment on the defendant's decision not to present evidence. That is understood to be what's called burden shifting. The prosecutor has the burden and is trying to put it on the defense by saying, hey, you didn't show anything, right? And that creates in the juror's mind an expectation. Yeah, they say, hey, yeah, come on, where's your evidence? But that's improper because that's shifting the prosecutor's burden, right? There is no burden on the defense. So this demonstrates a sort of a slightly ambivalent attitude towards jurors. We, in our system, we value jurors and we expect them to reach fair verdicts, but we also slightly distrust them. They're not lawyers, and they may not be capable of fine distinctions and the mental discipline of lawyers and judges. And there are many other procedural responses, especially rules of evidence, that stem from this ambivalence. We shield jurors. We shield jurors from information which we fear they may misuse, okay? And that's called prejudice in evidentiary terms, when a juror accepts certain evidence and use it for the wrong reasons. Think about it in the wrong way. And this, in turn, affects the order in which we do things at trial. So if there is a question about the admissibility of evidence, this has to be resolved before the jury hears about it and outside of their presence. And that is because we say, the expression that we use is, you can't unring the bell. So if the jurors hear the bell, that is the evidence, they don't have the discipline to say, oh, when I think about this case, I'm just going to ignore what I heard. We don't trust them to be able to do that. So for that reason, we have to do all kinds of litigation about the admissibility of evidence outside of their presence. Okay, I'm going to try to speed through some of this other stuff. The standard of proof is proof beyond a reasonable doubt. What does that mean? Well, if you asked, 50 lawyers, you'd get 50 different answers, because it is a verbal formulation that really cannot be quantified, right? What does it really mean? We do have other standards of proof. Proof by a preponderance of the evidence, proof by clear and convincing evidence, and we know that those are lower than the proof beyond a reasonable doubt, but nobody really knows what it means, and lawyers spend lots of time trying to figure out cute analogies to have jurors think about it in the way they prefer. Character evidence, as I said, is generally inadmissible. And this stems from the basic idea in our criminal law, that we are trying people not for who they are, but rather for their deeds, what they actually did. And this is, we recognize all of us probably have impure thoughts, maybe not the court, but all the rest of us have impure thoughts. But, we're not really, there's no interest in the community in stepping in and doing anything about mere thoughts. It's only when we cross the line into action that criminal prosecution is appropriate. So there is a lot about, a lot of procedural and evidentiary implications of this basic idea that cause a lot of litigation. I wish I had more time to give you some examples. I don't think I do. So if you are curious, ask me in discussion. Our exclusionary rule. which I understand is shared here in Brazil. What happens when evidence is gained by the police via illegal means? We don't let it in. We don't let the jury hear that evidence. The rationales for this I'm also going to skip, but we do have our justifications, and we can go into it later if you like. The key point to understand about the exclusionary rule is that it leads to greater uncertainty about the outcome of a case. So if I read a police report as a defense lawyer and I see, yeah, I think maybe an illegal search here and is here, a prosecutor reads the same police report, they're going to say, don't know what I'm going to be able to do with this case if this motion to suppress evidence is granted and I lose that evidence, right? So it both produces the need for more litigation because, you know, I say, yeah, there was an illegal search, and the prosecutor says, no, it wasn't. And the police give one version of the facts, and the defendant or possibly other witnesses give other versions. We have to, like, who's telling the truth? What's actually going on here? So we have to have a court hearing to litigate this and figure out whether there was an illegal search or not, right? So it both causes the need for more litigation, and it introduces greater uncertainty into the ultimate outcome of the case. I'm also going to skip over the right of confrontation. I'll just explain it very briefly. The right of confrontation means the right of the defendant to be present in court and look the witnesses in the eye and hear them denounce him personally, right? Directly, right? And to go after them through counsel, through their lawyer's questioning, and to put their story to the test via what's called cross-examination. Cross meaning cross in the sense of you are examining the other party's witness, right? The prosecutor has the same right. If the defendant testifies or brings in evidence, the prosecutor can also cross-examine the defense witnesses, okay? And the notion is that this confrontation and cross-examination will produce the real truth. People will say all kinds of things outside of court, but when they're actually there in court, staring the defendant in the eye, that's when the real truth will come out. That's the kind of the belief. And then I'll just mention very quickly that this leads to an evidentiary exclusion for what's referred to as hearsay, which is a statement that's made outside of court and not in that context of confrontation. And what this means is, you know, that statement is not reliable because it hasn't been produced in these special circumstances of confrontation. Therefore, if that statement is important to one side's case or the other, then you actually have to bring that person into court to testify. It's not sufficient to have somebody else testify about what that person said. All right. That's all I have time for on how we produce evidence in a jury trial. So now that the jury has the evidence, what are they supposed to do with it? How do they function? So jurors are first and foremost finders of fact. They judge the credibility of witnesses. They determine whether the elements of the offenses have been established by the prosecution. They determine whether any affirmative defenses have been made. The judge, on the other hand, is the referee between the two parties and rules on procedural questions and on the admissibility of evidence, and basically is the one who tells the jurors through jury instructions, which may be written or they may be oral, but they're basically directions to the jury on what they're supposed to do and what the law is in the case, okay? Jurors are supposed to only consider evidence that is actually presented in court. If they go home and go online and read about the case in the newspapers, or that's a form of jury misconduct and can lead to a case being overturned on appeal. Likewise, if jurors, in a driving under the influence of alcohol case, they go into the jury room, they say, those FSTs, those field sobriety tests, they don't seem so difficult. Let's try them. I'm going to stand up here and see if I can touch my nose 3 times. And, they're doing experiments and producing evidence themselves. That's all regarded as improper, okay? But once the jurors, all of the evidence has been submitted to them, they retire to a special room and they deliberate. What that means is they talk about the case and about the evidence, and they are supposed to decide and ultimately vote on whether the defendant is guilty or not guilty. As I said previously, in 48 states and the federal system, there is a requirement of unanimity. In other words, the jury all must agree on a verdict. And in simple cases, this can be done often if the evidence is relatively clear. This can be done in a couple of hours. But in complex cases, jury deliberations alone can last for weeks. And if jurors are stuck, if they even after urging, from the court, please, try to reach a verdict, but they say, sorry, we can't go any further. It's 10-2, 10 jurors for guilt, let's say, and 2 not guilty, and the 2 just won't listen anymore, right? They're at an impasse. Then the court declares what's called a mistrial, and the whole case goes back to square one. So that is a possible outcome. Okay, I'm almost done with this first part. I want you just to go back and reflect on what I've told you about these procedures, and again, to appreciate what an administrative feat it is to orchestrate and conduct a jury trial, and at what expense. So, first of all, you have to make sure that all of the relevant actors can be brought together at one time. You've got to have the defendant there, you've got to have witnesses, you have to have the lawyers, and you have to have the jurors. Compare this to a trial by a single judge that is characteristic of many other jurisdictions. So that judge might prefer to hear all of the evidence at one time, but given adequate record keeping, the court, a judge can afford to hear witnesses days, weeks, or even months apart, right? It's not really that big a deal. So that's a very administratively clean and simple way of going. We don't do that. So making 12 members of the community the finders of fact means that everything all has to be done at one time, because reconvening them for a witness, 2 months later would be an administrative nightmare, if not an impossibility. So you need bailiffs, sheriffs, the guys with the guns. If the defendant is in custody, they're needed to bring the defendant to court. They have to stay there all the time. They're there anyway to secure the courtroom. You need court reporters and court clerks to record the activities. You need the judge to preside. You need the lawyers, who are typically paid at state expense. I would guesstimate, this is not a figure that I've actually read anywhere, but my estimate is that probably 75% of criminal cases are the defense counsel is appointed by the court and therefore paid by the court. You have to assemble a jury through the methods I've described. All of these private citizens, by the way, are missing work, right? Although laws oblige employers to pay employees while they're on jury duty, this doesn't help the self-employed, and employers are not compensated for the loss of their employees' work. Just as a, well, I'll skip ahead a little bit here. I I also want to emphasize non-economic but significant costs of trial, which is the emotional toll it takes on lawyers, on the defendant, and often on witnesses. Trials are nerve-wracking affairs for a variety of reasons. They can be particularly gut-wrenching in sensitive cases like rape or child molestation, especially for the victim. But it is also hard for lawyers. I had the experience of cross-examining a child victim in a child molestation case. Let me tell you, that is an emotionally complex experience. It is not an easy thing to do. So, all of this has been designed to impress on you what a costly, cumbersome, difficult thing it is to actually conduct a jury trial. And that will position you better for the second part, in which we'll talk about plea bargaining, because these costs are essential. The understanding of the costs of jury trial are essential to understanding why plea bargaining happens. Okay? So I think we will now take a break. All right. 10-minute break.